Okay. Um, Thank you for being here today. I appreciate you meeting with me to negotiate a settlement for the Adams v. Chandler department store matter. How are you doing today? You good?
I'm good. How are you?
I'm good. Did you have a good week?
Yeah, did you?
Yeah, it was good. I watched Dancing with the Stars and I was kind of disappointed for some of the people that left, but otherwise
Me
it was
too.
good. Yeah.
Yeah,
Mm.
same.
So I don't know, we can just jump right into it. I don't
Yeah.
do you want to discuss non-monetary terms first and then we can just discuss money at the end?
Yeah, sure.
Okay.
Have the letter that I sent you pulled up?
I printed out a copy of it, but I do not have it handy right now at this moment, but I do have it on my
Okay.
hold on just one second.
Might be easier to just go down the list and
Yeah.
it's every. Mhm.
Okay. So the first thing is the letter, correct?
Yeah.
Okay. So I understand that hold on, let me split my screen. And it is not letting me do that. That's okay. Okay, so sorry, the letter. I understand that your client would like a public apology printed in the Daily Gazette, but unfortunately, our client is not able to issue a public apology. It's not typically standard for corporations to issue public apologies unless there's any sort of discrimination, and in this case, there wasn't any discriminatory conduct towards Dr. Adams. That being said, we are certainly prepared to issue a private confidential letter and apologize for the distress that the incident has caused Dr. Adams. In that letter, we would express our regret over the incident that occurred and apologize for the escalation that led to her arrest. We would also affirm that we value the dignity of all of our customers and that we continually review our customer interaction procedures on a regular basis. Is that something that you guys would be open to?
What did you mean by confidential letter?
Like that it would only be addressed to Dr. Adams and that it would just be a private apology letter.
Okay, but she would not have any restrictions on who she can show the letter to, right?
Well, we would hope that it could remain just confidential because it is just an apology towards Dr. Adams.
So I think the biggest reason that Dr. Adams wanted both a private and a public is because she is a doctor, so her reputation has been harmed. And because people in the community know about it, her main objective in this is to get her name cleared and to have everybody know that she was wrongly accused and that she just didn't steal. Because even with the dismissal, not everybody knows about it. And because it was made public by the newspaper, it reached more people than it would have if it hadn't. So if it's confidential, the private letter, she needs to be able to show it to people at work or people in her circle, community, if any patients bring it up. She just wants to be able to show something that um clearly states that she didn't steal and she, you know,
Yeah, no, I totally understand that. I mean, we could work with that as long as it's not printed in the Daily Gazette. I
mhm.
think that that would be okay.
Okay.
So we could issue that letter to Dr. Adams and if she feels the need to show clients or other colleagues in the community and everything like that, I think that that would be okay.
Okay. And who would the letter be specifically from?
It would just be from Chandler, like Chandler Corporation, but we would put the Chandler department store letterhead at the top, and it would also be signed by our CEO.
Okay. And what about Pat Curran?
Um, just because we want to protect all of our employees, we would express in the letter that we regret the incident and what occurred between the store manager and the store's employees, but it wouldn't be specifically from Pat Curran.
Okay, but it will it state I guess the parties involved and for the security guard and the manager at least and how they treated her and just their apologies for that.
Um, like I said, it wouldn't be specifically from Pat Curran or from Officer Flanagan,
But
but
would it mention them or at least state that they didn't behave as they maybe should have or with probable cause?
well, we're not going to admit any fault or wrongdoing. It would mainly be like we express our regret over the interactions that occurred with our employees, and specifically, we could say the store manager and the security detective that was involved in the incident.
Okay. And will it state specifically that she did not steal?
Um,
Or
that wasn't
what in the letter would indicate that that the accusations were wrong?
um, well, I could say that we could put language in there stating that like I said, we apologize for the escalation that led to her arrest
Hmm.
and that and like I said, and we could say
Maybe
that
like not investigating fully or not following, I don't know, maybe more reasonable procedure. It doesn't have to say specifically. I understand that you guys can't express like your own liability, but just something that because a letter wouldn't really mean anything to Dr. Adams if she's showing it to people and it's just saying, very general
yeah,
what
no.
the escalation.
No, yeah, I totally understand that. We could include in there that we continually update, like I said, our customer interaction procedures and regret how this situation even got to the point that it was at. So like we could kind of indirectly like say that in a way.
Okay. Um, I'm just reviewing what Dr. Adams specifically wanted in the letter. So will it specifically say we apologize then?
Yeah, it will specifically say that we apologize.
And whenever you say that you guys continually update your policies, will it say that you'll maybe review or train further or do
Yeah,
anything in the future? Okay.
yes, absolutely.
Okay, so I think if the letter acknowledges the store manager, the security guard,
Mhm.
and it's from signed from the CEO with the official letterhead, and she doesn't have restrictions on showing it, and it specifically does apologize, then I think Dr. Adams is okay with um not getting the public apology in the
Okay.
Daily Gazette.
Okay, perfect.
Okay.
Um, you said that you wanted to include a non-disparagement clause in the agreement.
Mhm.
We're 100% open to that, but we would also like to ask for a mutual non-disparagement clause. That way, it would protect not only Dr. Adams, but Chandler Department Store from any negative or damaging statements in the future, because we're also concerned about bad press and reputational harm.
Okay. But she will not be restricted on who she can talk about it with, like the incident in general and what happened. She
Well, because I know that you also asked for a confidentiality clause, I feel that it's a little bit unfair for Dr. Adams to just be able to talk about it with anybody, but then Chandler cannot talk about the incident at all. And that's why we asked for like a mutual non-disparagement agreement and then a mutual confidentiality clause, because that way, no information is being spread and no further tension will happen in the future between Dr. Adams and Chandler.
Dr. Adams cannot sign a confidentiality clause because she needs to be able to continue to clear her name if anything comes up in the future. The reason that we asked for the confidentiality clause is specifically because she is a doctor, so she can't have her personal information, um, such as like her mental health information or the fact that she retained attorneys. It just would harm her reputation even more. So that is why we asked for that. I don't think that would necessarily apply to Chandler if she's talking about the incident in general or trying to clear her name, because it's not like it's any of their personal information coming out, their mental health, anything like that that would harm their reputation. And she would not be, I think she could agree to the non-disparagement clause in talking negatively about Chandler, but she should still be allowed to discuss the matter and what happened, the fact that it was cleared and resolved. Does that make
Oh,
sense?
yeah, so a mutual non-disparagement clause, but only a confidentiality clause towards Dr. Adams. Is that what you're saying?
Right. And that can specifically be limited to just the fact that she retained an attorney, anything with her attorney information and her personal information that was disclosed during the case.
I totally understand that 100%. We're also concerned about the employees that were involved and being talked about, and we want to protect our employees. And so that's why we also wanted a confidentiality clause, or a mutual confidentiality clause in the agreement. Um, like I said, that way, no personal information about Chandler employees and no personal information about Dr. Adams, like you said, her mental health information, her personal information, the fact that she retained attorneys. We would just like to protect our employees as well with that.
So can we add a clause where she specifically under the confidentiality clause that she cannot maybe specifically mention their names? She can refer to them and maybe what happened, but not continue to talk about the specific employees.
Um, I think that would be okay. And then we can, I don't know if you would be willing to include like the liquidated damages clause, like a mutual one, so that way if either party breaches the terms of the contract, there would be a $20,000 punitive fine.
Okay. I think that would be okay. As long as, like I said, the confident, like she can still talk about the incident, but it's limited to not saying their specific names.
Yes.
Okay.
So a mutual non-disparagement clause for both parties, and then um we can both have like a confidential clause, but um as long as she doesn't name the employees or the people that were involved at Chandler Department Store, I think that would be okay.
Okay.
Um, let's see.
So, I know you brought up the breaching the clause.
Hmm.
I added something on here about that. Okay, so then where both parties are agreeing to, if they breach the contract, $20,000,
Hmm.
and Chandler also agrees to pay for all costs associated with going back to court.
Yes.
Dr. Adams, okay. And Dr. Adams will not have to pay for a breach for Chandler's cost, correct? For going back.
No, well, no, I mean, this wouldn't be going back to court. It would just be a punitive fine. So if either party breaks it, then I mean, Dr. Adams would have to pay, and then but if Chandler breaks it, Chandler would pay.
Okay.
The
Okay,
next,
so I think the
oh,
next
oh, go ahead. Yeah, sorry, go ahead.
the form of coupons or gift cards, including the free bottle of perfume.
Um, We can discuss that more if that's okay at the end, once we talk about money, if that's okay.
Yeah.
Okay.
Yeah, what would you like to go to next?
Um, the disciplinary, for disciplinary matters, it is protocol for us to make a report and of the incident, and then we include that in the employee's files. Specifically, there will be a notation and a report included in Pat Kern's file and Officer Flanagan's file, because I know that that was something that you had asked for in the letter.
Okay. And will that specifically state their the way they handled improperly handled the matter?
It will just kind of state how like how Officer Flanagan, he made the report before and of the whole incident. That would be what is included in the file, and then from Pat Curran's side, what happened at during the incident.
So there would be nothing in their report that says that there was misconduct or mishandling of the situation.
Um, we would include that in we could include that in the report.
Okay. I think that's what Dr. Adams is mainly looking for, is just that they're disciplined or that it's seen somewhere that
Yeah,
it was handled. Okay.
yeah, it will be marked in the file and notated with the report.
Okay.
Um, and then I think um it is the no trespass order.
Mm-hmm.
So we realize that there is tension between Chandler Department Store and Dr. Adams and the employees that were involved. And we want to make sure that there is no future misunderstandings. We would like to keep the no trespass order for the DeKalb store, but we would be okay with not having that for any other of the affiliate stores in the Midwest. And that's more of just to protect our own employees, to prevent future incidents and any misunderstanding and any emotional escalation.
I don't think Dr. Adams would agree to that just because she does live in DeKalb and it's one of the most popular stores that people tend to go to, and she does shop there regularly. So for her to not be able to go, I think that would harm her and possibly harm her reputation even more if it's known that she's banned from the store that she was accused of theft from. Um, as you know, she's got like friends here, she's got colleagues here. She does go shopping with them there sometimes. So if she's not able to go, I think that makes her look bad even to her circle and the people around her.
No, I totally understand that. We would be willing to continue to let Dr. Adams shop at the DeKalb store, but we ask that we can include a clause in the agreement stating that Dr. Adams is not allowed to bring any future claims or lawsuits against Chandler Department Store employees arising from this incident or the events that were referenced in the pleadings.
And that would only limit her to anything specifically from November 1st, 2024, not anything that could happen in the future.
Um, yeah,
Okay. Yeah, I think she'll be fine with that.
okay. So, as long as she doesn't continue to bring future claims or lawsuits against Chandler employees for this incident, then I think that we could lift the trespass order against her.
Okay.
And then now money. So we know that you're asking for $150,000. We feel like that is a little bit high. More so, we don't feel like there was a lot of reputational harm. I mean, when we deposed Dr. Adams, she said that she didn't lose any clients due to this incident. She, in fact, said that she remains busy and her appointments remain booked and that she didn't have any lost profits from this incident. And that there, she said that she had no proof linking the Daily Gazette and Chandler Department Store, um, the fact that there were no employees that she knew of that gave information or anything from Chandler Department Store. And so we feel like of 150,000 is a bit high.
She did. She didn't lose any patients, but she did lose her speaking engagement fee. And I think that was the biggest indicator that her reputation was harmed was because she had a good reputation to where she could be invited to speak at a conference that's attended by other doctors. So the fact that this was taken away right after this incident, right after the report was published in the Daily Gazette,
Hmm.
I think that would show that it did impact her reputation, and
Hmm.
she hasn't recovered that lost $50,000 that she was supposed to get, and she hasn't been invited to anything else. So I think that's where the $150,000 comes from is her attorney's fees, her medical fees from having to see Dr. Lee, her medicine and the lost speaking engagement and everything, her pain and suffering, her anxiety. It's
Yeah.
all of that.
Um, so we we feel like there isn't enough concrete evidence um to say that the speaking engagement was canceled just because of this incident. When we were deposing Dr. Adams, we asked if there was any reason given for the cancellation of the speaking engagement, and she said there was no reason given. I understand that it was after the article was published, but I mean, she said she only assumes that it was because of the article in the Daily Gazette, and we feel like that's not concrete enough for us to cover the whole amount of the speaking engagement when we really don't know if that's why they canceled or not.
Okay. I do think that if we did take it to trial, it would like indicate to a jury that it did impact her reputation just from the law speaking engagement. Because I think it is a very prestigious association that she was invited to, and it's a lot of money that she lost out on,
Mhm.
and she hasn't had another invitation. So I think it's circumstantial evidence, but it is strong evidence that she did lose it because of this.
Are you willing to work on this $150,000 price? I mean, that
What are
is,
you guys thinking?
I was thinking because she has around $15,000 in medical fees right now, and then 15,000 in attorney's fees. And then we would cover the next 2 years of medical expenses. So that would be another $30,000. I was thinking maybe, and then an additional 10,000 on top of that for emotional pain and suffering that she's endured. I was maybe like 70,000, 75,000.
Um, I think that's a little low. Let me pull up the specific damages that we have. There's a calculation that we use to calculate the damages, and
Mhm.
it kind of just takes the number of days that she's been in therapy and multiplies it. Um, and starting with her January therapy, it would come out to 145,000. So I think that, and that's just for the pain and suffering and the medical bill starting in January. So I definitely think 75 is low. Um,
Okay.
how do you feel about 130, 120?
Um, I feel I still feel like 130 is a little bit high. What if we counter with 100, and then we could include, like you said before, coupons and then a free bottle of the Mugler perfume, was it, that she
Yeah.
wanted? And that way that would cover um I think emotional pain and suffering and her future medical bills, and then part of the lost speaking engagement.
Okay. So You're offering 100,000. Would that still include you covering the cost for her medicine for the next 2 years?
That would just be like the blanket price for, yeah, for medical expense because right now she only has $15,000 in medical expenses. So the next 2 years would be about $30,000. And um, I mean, that would only be $60,000, but I think offering 100,000 would definitely an extra 40,000 there would cover any medical expenses, anything for medicine, and I don't know.
Okay. I think that if you're willing to also give her the coupons and the free bottle of perfume, that she would be okay with 100,000. That covers all of her costs right now and should continue to cover her medicine too.
Okay, perfect. So just to go over it again, we would issue the private apology letter. Um, and then in there we would state, like I said, our regret over the incident that had occurred. And with our employees, we can specifically name the store manager and the security officer. And she could share that with other people as long as employees are not named.
Mhm. Correct.
Okay. And then the mutual non-disparagement clause. And then it would kind of be like a mutual confidentiality clause as long as she doesn't name Chandler employees.
Mhm.
And then we would include the liquidated damages clause. So if either party breaches the contract, there would be the $20,000 punitive fine.
Okay.
The notation and report in Pat Curran's file and Officer Flanagan's file. And then as long as Dr. Adams doesn't bring any future claims or any lawsuits against Chandler Department Store employees arising from this incident, or like I said, the events that were referred in this pleading, we would lift the ban from the DeKalb store.
Okay. And under the liquidated damages clause, are we also including the breach of contract clause for Chandler where they agree to pay $20,000 for breach of contract and all costs associated with going back to court?
Yes.
Okay. And then did you cover already the damages? No, right?
Oh, the
Yeah.
$100,000 yeah, 100, I'm sorry, I thought that, yeah, just to go over that again, yeah, $100,000 in damages, then we can include the free bottle of the Mugler perfume and then some coupons.
Okay. Okay, I think that she would agree to everything.
Okay, perfect. Thank you for being just willing to work with us and putting a
Yeah.
good faith effort into getting to a settlement agreement.
Thank you, and thank you for meeting with us today.
Yes, thank you. Have a good day.
You too.
Bye-bye.
Bye.